The Supreme Court is now trying to figure out whether they should further restrict abortion access across the United States. But based on what we heard today, it seems like the justices may not even get into whether Americans should have access or not. Instead, they may focus on a legal technicality. So let me explain. The justices heard oral arguments this morning in a case involving a medical abortion pill called mifepristone, one of a 2-drug series used in most abortions in the United States. By the way, the FDA approved mifepristone almost 25 years ago and has been used safely and effectively ever since. Last year, a group of anti-abortion doctors and medical providers sued the FDA, saying the government was wrong when in 2016 and 2021 it expanded access to mifepristone and made it more available through telemedicine doctor appointments and through the mail. And they say there should be a nationwide block on the drug, even in states where abortion is legal. But based on the hour-and-a-half-long arguments today, it seems like the justices were very skeptical of those medical professionals based on a very important technicality that actually has nothing to do with abortion. The justices were very concerned about what's called standing. Standing determines who has been injured and therefore has the ability and right to sue. In this case, the justices were skeptical that the medical professionals who were suing the FDA had standing to bring the case in the first place. The lawyers for the government say those medical professionals bringing the lawsuit didn't treat women who used mifepristone. They didn't themselves prescribe mifepristone. And further, if those doctors had a moral or conscientious objection to treating women seeking a medical abortion, there are other laws that protect those doctors. Plus, the government said these specific doctors bringing the case were not injured by the FDA's decision on mifepristone. Liberal Justice Ketanji Brown Jackson tag-teamed with conservative Justice Neil Gorsuch to express their concerns that these medical professionals may be asking for way too much when they talk about a nationwide restriction.
Do we have to also entertain your argument that no one else in the world can have this drug, or no one else in America should have this drug in order to protect your clients?
So again, Your Honor, it's not possible given the emergency nature of these situations.
Counsel, let me interrupt there. I'm sorry. We have before us a handful of individuals who've asserted a conscience objection. Normally, we would allow equitable relief to address them. And this case seems like a prime example of turning what could be a small lawsuit into a nationwide legislative assembly on an FDA rule or any other federal government action.
As I always say, we should never assume which way the justices are ultimately going to rule based on the questions they ask during oral arguments. But it sometimes does give an indication which way they are going to lean. We are expecting a ruling in this case in late June.